Good morning. My name is Natalie Fanny Gonzalez. I'm the chair of the Economic Development Committee. We are here in a joint committee work session with the Public Safety Committee to discuss Bill 1325, licensing and regulations generally, picnics, dances, and other entertainment amendments. And we're going to go through the bill. We have the sponsor here as well, Delegate Don Lutke. And I'm going to co-chair this meeting with my dear friend, Councilmember Katz. I know there's a series of items that we need to take a look again, and I'm going to ask council staff to guide us, but before we kick it off, if my co-chair would like to share a few words, please do so.
No, thank you. We're happy to do this. I do have some questions in general, and I don't know when you want to go through that, whether you want to do them as you go through the packet or whatever. Okay, I'm good on otherwise.
Would you like to say a few words before we start?
Yes, and actually, there are a couple of, there's one amendment I'd like to propose now. The other amendments that are in the packet are ones that the sponsors, because Andrew Friedson, Councilmember Friedson is a co-sponsor of the bill, but that we are perfectly pleased with and consent to. But I just want to thank Mr. Gorzalak for his work on this with us to try and make sure we had wordsmithed it as appropriately as we could, and to our partners at MCPD for helping us in an ongoing fashion with these issues and to trying to figure out where and permitting, thank you, Victor, for being here, where we might be able to amend or enhance existing law to make it current for the types of problems and situations and scenarios that we're experiencing day to day now. So thank you.
And we were just joined by the other co-sponsor of the bill, Councilmember Friedson. If you have a few words to share before we kick it off.
Yeah, just thank you to the Joint Committee. Thank you to my partner in stopping crime, I guess, in this case, Councilmember Lutke. This is a significant issue in both of our communities. It's something that we need better tools in the toolkit to actually enforce. It's a really devastating response when residents reach out on things that are clearly against the law, that are clearly not allowed, that are completely inappropriate and obscene to be occurring in any community, in any place, but particularly in residential neighborhoods. And when the response is, well, yes, it's not allowed, yes, it's prohibited, but there's really not much we can do about it. And this is an effort to do more about it, to have the punishment actually fitting the crime, and to be able to actually provide our enforcement team a better opportunity to actually be able to address these issues, to hopefully stop them before they start, but at the very least to ensure that there is appropriate response when these issues occur. I'll just note the series of items and events in my district in particular. This was hundreds of people at a private residence. Rooms were rented out. Bottle service was provided. There was so many people that there was a shuttle service, and the local county recreation center was used as off-site parking, where people parked and they were shuttled in to this event. The level of disruption that created, the obscenity that occurred in that residence is just something that we need to clamp down on and address. These are not, organizations and other entities that are having events in private residence. These are private promotional companies that are utilizing homes to put on business activities, and those business activities can lead to some obscene dynamics. So appreciate the indulgence and the fact that we're taking this up. Look forward to addressing some of the fine points and to moving this forward.
Thank you so much. And I want to welcome the Department of Police, the Department of Permitting Services, and the Department of Environmental Protections for being here. We're going to start with our legal staff. We can please go through the report, go in the same order, and whatever is missing, new amendments that may have arrived, we'll leave them those at the end, okay? So people can easily follow.
Great.
Thank you.
All right. Jim Ogorzalek for the record. Been asked to pronounce that for everyone. So Bill 1325, licensing and regulations generally, picnics, dances, soirees, and other entertainment amendments, was introduced on May 6th. The lead sponsors, as noted, were Council members Ludke and Friedson. Co-sponsors are Council members Albernaz and Belcom, Council President Stewart, and Council members Glass and Katz. A public hearing did occur on June 10th. So as background, currently the county code prohibits any person from holding an unlicensed or unpermitted, quote, picnic, dance, soiree, or other entertainment for gain or profit to which the general public is admitted, end quote. And that's in Montgomery County Code Section 30-1. This is an extremely old section of the code, originally dating back to like 1918. That was the last amendment to it was, I believe, in the 1960s. And the penalty back when people attended soirees, the penalty for a violation for this prohibition is $25. It's a misdemeanor. So part of the complication is that it's actually enforced by the state's attorney's office. But the state's attorney's office, just as far as we can tell, this isn't something that is enforced at all, this provision within the county code. And so part of the effort here was to breathe a little bit of life into this and use this as the mechanism for addressing this community problem. So Bill 1325, as introduced, would clarify by express enumeration that a party is contemplated in the list of prohibited activities. And so that is added in where it said picnic, dance, soiree, or other entertainment. It just expressly includes party there. So it's prohibited when it's unpermitted or unlicensed, and that's, again, in Section 30-1 of the code. It excludes, as introduced, from the prohibition for-profit activities benefiting certain categories of entities under the Internal Revenue Code, and as introduced, the bill included an enumerated list of certain 501c and 527 tax-exempt entities. The bill also establishes that the violation is a Class A violation. This is so old that it predates, the 30-1 is so old that it predates when we had Class A, B, and C violations enumerated in the code. So it clarifies that this is a Class A violation. And then also sets an increased maximum civil penalty for the violation when it occurs at a residential party. Currently, a Class A violation for a civil violation is $500. The maximum we are allowed under state law to impose is $5,000. So when a 30-1 violation would occur at a residential property, it is now $5,000 under this bill as introduced. The bill also does the same mechanism, increasing the maximum civil penalties to $5,000 for 3 other code violations that tend to frequently occur in tandem with these house parties. Setting aside the code, the citations, they're basically related to noise level and noise disturbance, commercial activity unpermitted in the zone, and failure to obtain necessary conditional use approval to operate an outdoor-indoor recreation and entertainment facility. Those code sections are all either enforced by the Department of Permitting Services or relating to the noise disturbance by the Department of Environmental Protection. We have staff from both of those agencies who enforce those. We also obviously have the Department of Police here, representatives from the Department of Police who have been intimately involved with many of the council members and many of the community members where this is an issue, and who often are obviously the first responders when a call comes in related to these large parties. I'll briefly run through the impact statements. The Office of Racial Equity and the Office of Legislative Oversight, in its Racial Equity and Social Justice Impact Statement, found that it was indeterminate. Essentially, the OLO noted that there's not enough information because racial demographic data is not collected to assess the impact of the bill. The Office of Management and Budget found no fiscal impact related to the bill. The Office of Legislative Oversight found no climate impact to the bill. And the Office of Legislative Oversight found an indeterminate impact on the bill, essentially due to the lack of data on the prevalence of these parties. They could not determine a net economic impact. At the public hearing, there were two speakers, both of whom testified in support of the bill. They were community members affected by one of the locations where these commercial house parties have been repeated. I believe they both lived on the same block or cul-de-sac, so they were deeply affected and testified to what they experience. I can either pause here if any of the council members have questions about as introduced.
My co-chair.
Yeah, thank you. First off, thank you for all your work on this, and to the sponsors as well. I'm very much in support, but the question that I have is, who do you cite? If I have a house and I rent it to somebody, who do you cite in that case?
Speaking for DEP, we would cite the property owner.
So you'd cite the property owner, and then what happens if the property owner doesn't pay?
Well, we go to court, and they would issue a judgment against them.
And so you get the judgment. So then ultimately, eventually, they would pay for this, I guess. And then my other question is for permitting. It says in here on page 2 that you have to get a permit. Is there a reason you can withhold the permit from somebody applying?
Sure. Victor Salazar for permitting services. If the use is not allowed in the zone, then we would not permit the activity.
But is that, so this use, if someone says, I'm having a party, they don't need a permit unless it's for profit, right? Or
They're charging money, then yes.
Yeah, okay.
We would consider that a conversion of the residential property to a commercial use.
So you would say no, and at that point, okay, all right. My concern is that someone needs to figure out that we can't do it, and they need to know we can't do it. And I want to make sure that if you charge somebody, that they're going to pay us.
And for permitting services, I want to amend what Steve said earlier. For us, we would charge the property owner, the person renting the property, and the entity. If we knew who they were, they would all get citations from DPS.
It's good answers for all of it. Thank you very much. Thank you, Madam Chair.
Thank you. Councilmember Barcombe?
Thank you. Just a couple questions, and I think that you may have answered the first one. So if the event is not allowed in the area, then you don't get a permit. So it's not that these parties would go on, they wouldn't be cited for I guess not having the permit. They just can't happen in residential areas. Is that correct?
That's right.
Okay.
And so we would issue a violation if we found out it happened, to ensure that, it serves as a deterrent to anyone else who may want to do it. But they would not receive a citation from us unless they had the event. But we would go out if just recently, and I'll just, I don't know if I'm stealing your thunder. The 5th District, the LT here forward to our department intelligence about a particular house party that was going to occur over Memorial Day weekend. We dispatched an inspector and we contacted the property owner and we let them know that the activity was unpermitted. They were charging, it was advertised on the internet that they were charging a fee for people to come. And so we actually referenced this bill, or our inspector did, and told them that potentially in the future, there will be a law that is put into place that increases the fine amount from $500 to $5,000. And that information, coupled with a couple of additional visits from police, deterred that activity from happening. So you haven't even put this into law yet, and you're already reaping the rewards of the deterrent that the $5,000, just mentioning that number, I think had a big impact on the people who were putting that event on.
Okay, thanks. And then so what do you do about parties that are not not fundraisers, but aren't charging, just parties that just get out of hand. Is that a noise ordinance issue that you deal with then?
If it was a private party, DPS would not be involved. So most likely, if people have a complaint, they'll either call him about the noise and MCPD in the moment when the place is really out of control, then it's MCPD who would go handle the in the moment violations.
Good morning. Assistant Chief Darren Frank, Chief of Patrol for Montgomery County Police. First of all, thank you to Councilmember Lutke and Friedson for taking on this issue. It's a very difficult one for us in law enforcement because we answer the phone 24/7, and that's where people call for help when parties like this goes on. So in reference to the private event, yes, police would get dispatch and would look at the noise complaints. Lieutenant Mahoyne, we've kind of tasked him to coming up with our newest training bulletin for officers so they understand what is a bunch of not confusing, but just odd different county regulations that officers can enforce. And so we try and go at it and talk people into coming out of their party and turning the music down. That's the first thing. Please turn the music down. One of the problems we have on the weekends when we have these problems is the Department of Environmental Protection doesn't have 24/7 coverage. And the law as it's written gives them enforcement capability because they have to have meters and things like that. But we're looking through those issues. We're working with the county executive to find other options there. And we're also working with the fire marshals to look at can we shut these things down if there's a issue with how many people are there. And we're using those tactics in all of these events because really they are a tragedy waiting to occur, unfortunately, just because you've got literally 500, 1,000 people coming to a place that wasn't designed to hold those folks. There's no security plans. There's generally, well, I will say for the Woodfield event, they hired security, but for other events, they don't have security. And they're in these large homes that are tougher for us to get to. It's not like downtown Silver Spring where we have a lot of law enforcement presence. So being able to disrupt these with the help of our partners in DEP and permitting services is the best option. But if not, we're also working on the other end of it too.
Thank you.
Yeah, Steve Martin with DEP, just a couple points of clarification on our responsibility. So thank Victor. So we can cite both the person causing the noise disturbance, in other words, the person hosting the event, and the property owner. Noise code allows us to do that. As was mentioned, we're not a 24/7 agency, but if we have some prior notice, we can have staff attend. And one thing I want to make clear is that DEP staff at one of these parties cannot turn off the music or force the party to shut down. All we can do is document a violation, and then we can cite them for that violation. And even if DEP staff are not there, so there's two sections of the noise code. The first one is we're there with a sound level meter. We take readings, and you're in violation of the standard for the time of day. That's pretty straightforward. But if we're not there, there's a provision in the code called the Citizens Two-Party Noise Disturbance Complaint Form. So that allows us to take enforcement action based on the testimony of two witnesses. They're supposed to be independent witnesses, adult witnesses. And if they're willing to complete the form and willing to go to court and testify on behalf of the county, then we can issue the citation. And we rely on that quite a bit, actually, because parties happen all the time, and we don't get notice till the day after or 2 days after, if it was a weekend.
Okay, thank you. One last question. And this may be for the sponsors of the bill. It's noted that it's a residential property. So what about our rural areas? Is it what happens with unpermitted parties out in the ag or in rural areas?
For DPS, we follow the same process. We validate, we look at the zone, we see if the use is allowed in that zone, If it's unpermitted, then we issue a notice of violation and try to educate the violator. And if they do not comply, then we will issue a citation and pursue enforcement that way.
So, but the bill specifically calls out residential property, line 20. I didn't know if that was a specific definition that excluded areas that aren't in residential areas. I think I'm going to turn to council because the intent is these are not allowed in the AR zone without a permit, and so that it should apply. So if we need to.
Correct. No, that's why we specifically did not say in a residential zone or an R zone. When we refer to a residential property, we're referring to a property that is that is used as a residence.
It's not referring to the zone. Okay, but the, so if festivals, events, that unpermitted events that happen out in the ag reserve that aren't in an actual home, because that happens, then they don't, the fine isn't $5,000.
Correct. The increased fine, as introduced, the increased fine would not apply if it was if it was not at a property that is used as a residence. So if it is truly just, now if it was a farmhouse in the ag reserve, it would still be a residential property. But if,
Right. It's
yes.
like it's a field.
Right.
So, right, so I guess like to the point, this would apply in the AR zone to the extent that there is an agricultural use property with a residence on it. If it is fields only without a residence, this does not, the language in the bill as introduced does not encompass that. All right, thanks.
Councilmember Glass.
Thank you very much, Madam Chair. I appreciate the sponsors for putting this forward. The testimony we heard at full council, particularly among the residents along Woodfield, was horrifying. You know, being checked by private security when they're pulling into their own driveway is horrifying. And so I appreciate this legislation and being an original co-sponsor to it. Over the weekend, there was one resident in particular who had checked out the council agenda and saw this was coming before us today and asked very specifically whether or not this would affect fundraising for either political or nonprofit, and I assured them it did not. And so glad that was already in there, assuaging anybody, because I think the concern was of swatting of a political party that they did not support, right? Something that has already been taken care of in this legislation, but other things to think about. And as this conversation is continuing, I think it's just really important for residents and property owners, homeowners, to understand the series of events of what will happen. So say there is a party that is going on. Someone calls 911 or 311, but presumably they'll probably call 911. What happens?
So the process actually starts before then. We are actively seeking information from the public about parties. And this is such a known issue in the community that when people spot them, they will send the notice to a district commander or send it to headquarters. And at that point, we get with our partners and we dispatch a group, if you would, to go meet with a property owner beforehand. And what I will say is in many of these events, we have gotten a heads up before it occurred, and we're able to do that. Now, some of them, Woodfield's an example, but there's been other ones in other districts where they didn't care because they make so much money off of these events. They really didn't care about a $25 fine or
Cost of
anything.
doing business.
Yeah, it's cost of doing business. Just write the check. So our folks will go out, and as Mr. Salazar noted, we had a success recently disrupting an event. But when they call 911, our officers will respond and start to assess. This is one of the challenges is when the party's going on. If it's Monday through Friday during the day, that's pretty easy. We can call over to our partners here and have someone dispatch and deal with it. Otherwise, our officers are then left to deal with figuring out what's going on here. With juveniles, it's easier. If we have set protocols to figure out if it's an underage drinking party. And once we do that, we have a few more tools in our belt to deal with that. When it's not juveniles and it's adults, that becomes a different story. So we're looking at all the options that we can do with it. The first thing is, hey, folks, you need to turn down your music because we don't want to disrupt anyone's party. If we figure out it's a commercial, like we meet someone that's coming off, they have a flyer, they have something on their phone, we start gathering information. So as we start gathering information, we figure out what we need, and we've had some great meetings now, figuring out what everyone needs from us, because again, we're out there. So we start collecting evidence at that point, trying to identify the homeowner, trying to identify the promoter, trying to identify whoever rented the place, if it's one of those Airbnbs. And we start building a case so that after the party, if we can't get them to successfully shut down, if we can't get them to calm things down to a level where peace is restored, then we can follow up and work with permitting and work with environmental protectionists to take more enforcement action. In worst case scenarios, we would call the fire marshals to see if perhaps they can make an assessment on overcrowding. Like, for example, you've got a deck there and you've got 200 people on it at a pool party, right? Again, another tragedy waiting to happen, and fire marshals have the expertise to look at that and say, yeah, that we're going to stop this right now. So there's a bunch of different layers, but they're all difficult because I have the officers, the police officers, and even our inspectors, no one short of the fire marshal saying this is an unsafe area and shutting something down, and I let them speak to that, which is a difficult standard in and of itself. We can't just go in and say, yep, this is over, get out. We can do that with juvenile parties because obviously there's a lot of issues going on there, and we have the authority to shut that down, but for adults, we don't.
I think that was really important to articulate, and just setting expectations for residents, that this is legislation that is to be a deterrent, right? Recognizing if there's a party that gets out of control, heavy fines will be levied, and which leads me to the next question, and perhaps for DPS or DEP. What is the thought process as to when to levy a fine against the homeowner who rented their home for a short period versus the party organizers or anybody else?
Well, I mean, our enforcement response will be geared towards the public outrage about the event. I mean, if we had one complaint, then we would probably follow up with the homeowner and, educate them, possibly issue them a notice of violation and have them submit a plan for compliance. If it was particularly egregious, then we could go straight to the now $5,000 citation to both the host and the property owner.
I think this needs to be vetted out a little bit more, quite frankly, because a well-intended homeowner who puts their property on any one of the platforms, and I'm curious to know what platforms most of these things are being found on, right? Or whether it's just gone viral through any of the social media apps. But somebody who is allowing or, quite frankly, renting their space for this purpose might be very unaware of the intentions of the individual or individuals who are renting their home. And then to see what manifests in a gross way, quite frankly, and then to leave out, let me rephrase it this way, to then levy the fine against the homeowner, who might not have been a good neighbor, but might not have been malintended, then to let the party promoters off the hook who have legitimately made money, right? I think this needs to be thought through. I don't know if it's in the regulation or if there are other thoughts. Yeah, MCPD.
Good morning. I'm Lieutenant Mahon, Deputy Commander in the 5th District. Thank you for having me here. Speaking to that, certainly I could speak to my experience with the Woodfield residents, and that was an ongoing thing, right? That wasn't one party that happened, and then we went in and did what we did. It was an investigation that took, unfortunately, longer than it should have because maybe we didn't have some of those tools in the toolbox. However, it was an investigation that was done over a period of time where we were able to definitively say, yes, this is the person responsible, right? So we weren't going out and just criminally charging somebody that may have thrown one party and may or may not have done exactly what you speak to, which is, hey, I just rented my house. I had no idea this was going on. That's not our intention. I don't think that's the intention of this bill as I read it anyhow. So there is some investigation to be done. It might not happen right in the day of that. You might get a citation and say, hey, and of course that's the court's process too, right? Is if someone is able to prove, I had no idea this was going on. That's kind of the intention of us doing this investigation. But again, as Councilman Frieden said, it gives us that ability to have a little bit more power to enforce these things, if that makes sense.
Yes.
Yes, if I can just clarify a little bit. So typically, as both Mr. Salazar and Mr. Martin mentioned, the property owner is cited, and then also, if possible, if we can determine the identity of either the promoter or just actually the person being very loud, for example, that individual will be cited. That is information that is obviously much more challenging for the county to determine than the owner of the property. It's readily apparent in property records, so you can cite the property. So that one reason why property owners are often cited sort of across the board by our agencies in both this context and in all sorts of contexts is that we can easily determine who the proper defendant is. It also has a benefit to Councilmember Katz's line of questioning before about actually getting payment because it is easier to record a lien against the property, a judgment lien, that. So to your point, Councilmember Glass, about the issue of an individual who might rent their home with good intentions and following all applicable laws relating to home shares being wrongfully cited. First, to Lieutenant Mahoyne's point, that would be part of the prosecutorial discretion from the Office of the County Attorney in determining not to seek the $5,000 fine, to maybe dismiss the fine altogether as to that individual. The other useful piece, though, in citing a property owner, that assists the Department of Permitting Services, the Department of Environmental Protection, or also the Office of the County Attorney in determining the identity of the party promoter. They can now issue a subpoena to Airbnb or another home share program to find out who the individual was who rented that residence. And so even if ultimately the goal would not be to punish the well-meaning property owner, it could be a useful tool to get to the actual promoter. Who knows, maybe even get that person's account shut down on Airbnb or something like that, but also get us the name of the individual who we actually want to cite to prevent this behavior.
That is very important information, and I will assume that a well-intended homeowner, when slapped with a fine, would say, oh my gosh, not me, look at all these emails and text messages, go after this person. And as long as state or local law allows the pursuant of that, that's great. Last question I have. What are the platforms that you found facilitate these parties most?
Some of them are as bold as going on eventbrite.com, which is an event hosting site, right? And literally just putting the address and saying, hey, we're having a pool party on this date, and they get sold out on Eventbrite. Mostly social media, though, Instagram, TikTok, things like that, and they'll host it. A lot of them, they try to be clever about it. They'll wait to post the address, or they'll say, hey, DM, do a direct message for the address. So typically that's where we're seeing it.
Thank you.
Councilmember Lorian Sells.
Thank you, Madam Chair, and thank you to the co-sponsors for the bill's introduction. I just had a few questions. Most of them have already been answered. But I know that the OLO report did not have specifics on where these parties were occurring. Our responding officers, do you have any information on where these unlicensed for-profit parties are occurring, like which residential neighborhoods, if there's any trending information, or how many citations have been issued under this particular violation?
So our experience was we saw a number of houses in the Potomac Bethesda area because they're very large, and there's some folks that just have properties there that rent them out. So we've dealt with those over the last couple of years, and we've pushed them around because of our preemptive efforts. I will say it's kind of like what we've dealt with the car rallies. We have a lot of preemptive efforts, and people will go to other jurisdictions because they don't want to deal with us. So that's been successful. But Bethesda, Potomac, we've also, Damascus, we've now seen this up in that area there. The last two events was the ones probably, I could probably hit maybe my driver over to their backyard on Woodfield. And then this other area was actually on the other side of 27. So these promoters look around for these places that they can get. And I will say, going back to Councilmember Glass's, a lot of these homeowners are just unaware. And again, to our intelligence ability and to our citizens, see something, say something. As soon as we've contacted a number of them, they're like, oh no, canceled. And they cancel everything before it even starts.
Thank you. I shared those.
I can speak to the specific addresses that DEP's been involved with.
Oh, okay.
If that's what you like.
How many in the past year, would you say?
There's 6, and that's actually over the past several years.
You said that's covering how long?
Over the past several years. Well, the first one started 2018. First one goes back to 2018.
Okay,
But most of them have been the last year or two.
okay.
If I could clarify that, there's
Yeah.
been more incidents. And what we're doing here and why we're all here together is we're kind of collaborating on how to deal with this, and we're coming up with a playbook, if you would, for our officers. So first, our desire is that these enhanced penalties go to continue to help us to disrupt these events before they occur. But we're putting into play a mechanism that all our officers will know, because again, we're the ones that get called all the time. And we didn't have a guide that says, okay, you need to gather this information, you need to call DEP, you need to call permitting services afterwards. We get there, we deal with it, we calm things down, and then we go because we're off to the next call. So now Lieutenant Mahoyne is crafting our SOP to deal with these, and we'll be ensuring that all of the proper notifications get to our partners, because they may get a call separate of it, and we're all going to work together on the issue.
And I'd just like to add, for DPS, it's similar with DEP. We've had this kind of complaint going on pre-pandemic. But after the pandemic, several property owners admitted to our inspectors that they were holding these parties to make money because they were trying to make their mortgage, or they were doing other things with the money. And so over time, I think that the framework of supporting MCPD as the first responder that we've developed together, I think it's in its infancy, but so far it seems to be working. The cross collaboration between agencies and involving for the first time the fire marshals, who do have the ability to say there are too many people in this house and we're shutting this down until it's within acceptable limits. So everyone has to leave that doesn't live here. And so I'm just going to leave it at that. But I think that overall, we get complaints offline, 311, or directly to our office or directly to our director sometimes. And we've gotten them all over within the last several weeks. We did get one property just outside of the CBD of Silver Spring. So mostly the houses are bigger, but it doesn't mean that they're not happening in other areas as well.
Thank you, and that's one of my concerns is, increasing this fine from 25 to 5,000, and the fear of pushing these parties underground and making them even more unsafe for the populations that engage. And so I'm wondering if this bill is, I mean, we don't know if it can impact specific communities or cultural gatherings. I know that you've received complaints, more than 6 probably, but not all have been assessed.
Right. For those events, we've generally found that, again, they're not for profit, and that's one of the important things on this one. And we certainly have the carve out. There's the carve out for fundraising for official groups. As far as forcing it underground, a lot of them are already underground, and again, it's just this is a much greater tool for disrupting, because I will say we've talked a great deal. We don't want to arrest our way out of anything. We actually don't want to cite anyone. We want to tell them, you are going to get cited if you have this, and it's going to be $5,000, and then you got to pay your lawyer fees, and then you got to pay, and that's an effective deterrent.
Okay. I know that the OLO report didn't cite any demographic information. Are we able to collect any demographic information on the citations that are assessed or the violations assessed?
We can, so moving forward, and Lieutenant Mahoyne's making a note I can see right now, we can give instructions for, at least from the police side, for our officers to just make sure that in the standard report, there's identifying information, that's observable identifying information.
Yeah,
that could be
geographic information
Sure.
as well. It may mean we have to increase communication or, make people more aware in specific communities if we see repetition. So this collection of additional data will help guide implementation of this legislation. And, it's not happening as frequent, so hopefully we can, reflect on this legislation and see how useful it's been if we're not seeing any violations because of the fee. It would be good to reflect on how impactful this has been in a year.
I'm aware of one property in Burtonsville that might fit the mold you described. It's a 5-acre residential property, and they host, this year they're going to have 9 Hispanic heritage events there. We get complaints about those. We have cited the property owner and the promoters of separate events out there.
Okay.
So,
And are they doing this under the guise of a nonprofit organization?
not that I'm aware of.
Okay. Okay.
The property owner just leases the property out to various groups that hold these events, like they're having
They're charging, or they're not charging?
they may charge. I mean, I haven't been there personally during one of the events, but
Oh, okay.
they have the DMV Colombian Festival, they have the Central American Independence Day celebration, which happens right around September 15th, and other things throughout the year.
But those are permitted, because unless it says that there's a charge for,
Right, if
Attendance.
they're not charging correct, we permit it.
yeah, because they're not charging.
That still doesn't mean we're not going to get complaints, though.
Oh,
It still could be
yeah.
a violation of the noise code.
A noise code, but not necessarily this.
Right.
Okay. All right. Thank you.
Thank you so much. We have a couple more questions before we go to the staff report, which we haven't started. But I will say, remember, everyone watching, we're not after people who want to have fun in a healthy way. We're just going after those who are abusing and violating the system, okay? I'm going to continue going to quinceañeras every time you invite me, as long as they're not being charged. Councilmember Lutke.
Thank you. I know, my neighbors are having a wedding in their backyard next weekend, so party on Pond Road. I did not say this at the outset because I didn't want to get down in the rabbit hole of property law, but, there are, just to ease everyone's minds, to the extent that there are not direct that the homeowner themselves, and remember, if you are a property owner, it comes with certain rights and it comes with certain responsibilities, right? And property law has different classifications for who is or isn't on the property at a given time with or without the landowner's permission. So to the extent that there are contractual arrangements that someone has where they're renting their property out to someone else, again, a court may or may not excuse the actual landowner at the end of the day. Depends. But the landowner may, based on the terms of their rental agreement, have a cause of action against whoever rented. And so there are a host of different legal remedies to the extent that the person who receives the actual fine gets a fine. There may be a separate cause of action that allows for that to be remedied. So I just wanted to make sure that people understood that, because we have had other discussions at council about Airbnb in particular and Airbnb pool parties that have gone sideways. So that's fair. And I also wanted to make clear, and I want to thank Lieutenant Mahoin for his deep dive into this and his partnership on this work. I know my constituents on Woodfield Road certainly appreciate you. They're big fans. But diving into other aspects of this too, I'm looking at noise in a deeper way and our noise ordinance in a deeper way, so stay tuned. And a term I had never heard of until we started working on this, because, and correct me if I'm wrong, it is a common law cause of action from the 1800s called disorderly house. Yeah.
That is correct, yes.
Right. And so what might have been happening in the 1800s, that what might have qualified under common law as a disorderly house might not be what it is in 2025. And so I'm going to be taking a look at that too. That may be a state issue, but that is something certainly, again, lots of different pieces involved with the types of things we're seeing playing out in our community.
We'll stay tuned for that one.
Yes.
Last word, Councilmember Mink.
No, appreciate the sponsors on this, and we have had some issues that are comparable in my district as well. There was a for-profit issue in Hillendale, and then okay, that's interesting, and then we also had an Airbnb property where it was different people who were rotating in, so not all of them are for-profit, harder to discern what was actually happening, and like many different departments and agencies being involved and being frustrated, and so this is legislation that is very much needed, and I'll be supporting it. Thanks.
Thank you so much for that. If we can go back to legal staff, if we can go please to the report.
Absolutely. So there are 4 items, 4 issues for the committee's consideration set forth in the packet. So we can just go through them each in order, including to the extent there's a decision to offer the amendment, and second, a vote would be helpful. So the first is to expedite Bill 1325. As introduced, the legislation will become effective 91 days following enactment. Obviously, for obvious reasons, due to the majority of the events tended to be addressed by this bill occurring during the summer, that window would make it so that this really wouldn't have a practical effect until 2026. So council staff proposed that this bill be expedited. That would require 7 votes at full council.
Councilmember Luque.
Yes, I'd like to move to adopt the proposed amendment, adding lines 29 through 31.
All in favor? Yes, without objection. Thank you. Next.
Thank you. The second proposed amendment relates to the interplay between 30-1B and 30-4 within the code. So this relates a little bit to some of the conversation that was occurring before. So as presently drafted, or as presently in existence, the county code already contemplates that a bona fide nonprofit entity can obtain a permit for what is referred to as a benefit performance, and there is a very long list. There's already an infrastructure that the Department of Permitting Services has in place. If a nonprofit entity fails to comply with 30-4, it is already actually a Class A violation. That section of the code has been updated. And so it was after introduction, the Office of the County Attorney identified that as introduced, 30-1B, which had exempted certain nonprofit entity, tax-exempt entities under the Internal Revenue Code being exempted might create just some sort of internal cognitive dissonance within the code, within 30-4 and 30-1B. And so along with the Office of the County Attorney, council staff reworked some of it and thought that the best mechanism to move forward, and this is set forth on pages, I think it starts on 4, and bleeds a little bit onto page 5 of the staff packet, would be to move where those tax exempt entities are so that they're no longer exempt from 30-1, but rather in 30-3B and C, where the fines are ratcheted up to $5,000, those entities that are tax exempt under the Internal Revenue Code would not get that increased fee. The reason we went with this mechanism was that it just leaves the landscape in place. We're not messing with 30-4, we're not messing with that. The other thing I would note is the reason that we actually included a specific enumerated list of Internal Revenue Code tax exempt entities was so that an individual being cited who is the prototypical promoter that we're actually trying to get can't later claim, oh, this was a bona fide activity. If they are willing to falsify an IRS code, we are happy to pass that on to our federal partners, and then they can deal with the FBI. So the idea there was that clever promoters couldn't try to escape the enforcement of the law.
Love it. Without objection? Correct. All right, let's move on.
Seconded? All right. And the third section, and sorry, I just did want to clarify, Councilmember Katz, you had stepped out on the vote on the First Amendment related to expediting. I just wanted to get your vote on the record. Okay, great, thank you.
I'm good. I didn't leave for that purpose. Yeah.
I checked with
To
him as soon
avoid
as he
that.
got
Yeah,
here.
she did, yeah.
Number 3 is clarifying that related violations are increased only at residential properties. This is the clarifying intent of the bill. So in 30-3B, there is a reference to the increased fines when they occur at residential properties. In 30-3C, that same phrase at a residential property does not exist. There could be a potential loophole where a 30-1 violation occurs at a non-residential property, but now for those three associated violations, those could theoretically, the maximum fee is now $5,000. That was not the intent as drafted, and I appreciate OCA pointing that out to me. And so this is just a very minor fix to clarify the intent at introduction.
Without objection?
Right, and then the final one is just a technical revision to amend lines 27, 28. We typically note of the zoning ordinance after references to section 59.
Without objection.
All right, and then just the final vote for the whole thing.
You don't have anything else, right? No. Okay, beautiful. With that, my friends, with the joint committee, without objection, this bill is approved.
Yes.
Yeah. To go for the, yeah, of
Thank you
course.
very much.
Thank you.
Thank you so much for coming, everyone. This meeting is adjourned.
Lots and lots of produce out, and I really